Hello, welcome to another immigration art video. My name is Art Serratelli, and together with Mara Mijal, the two of us, we're the partners over here at Serratelli Mijal, PLLC, Immigration Attorneys at Law. Mara and I and all our case managers, we provide a full range of immigration legal services. We've got clients in all 50 states, and we've got clients all over the world. So, if you've got questions, send us an email, give us a call, try email. Email's your best bet. And before you know it, we'll be answering questions and getting you on the right path with the right strategy to accomplish the goals that are right for you. Today's video is about a quick overview. I just want to give you an idea of what immigration is putting out there in terms of its apparently orchestrated, comprehensive entrepreneurial program offered to the general public to encourage the entrepreneurial immigrant. What this really is, in fact, is a bunch of baloney. It's taken a bunch of old stuff. The same rules I've been using for 17 years, and these same rules, which are grounded in the 1965 immigration law, which applied to entrepreneurs in the 21st century, is ridiculous. It's ridiculous. My attempt to portray to you in a realistic way what really is going on with the immigration's self-proclaimed entrepreneurial program, and which parts of it are baloney, which parts of it are grounded in fact but aren't as rosy and cheerful as they make it sound, and which parts of it are for real. There are some parts that are real. I'm not a total cynic, but I'm pretty close. What the Immigration Service is doing is packaging the same old junk as entrepreneurial pathways. They're making up fancy names. It's all the same stuff. Let's take a look. So just to give you an idea what these entrepreneurial pathway suggestions are from the Immigration Service, I'm going to read them. I wrote them down. I'm just going to read them to you and throw in an idea or two after each one. Are you ready? Number one, the B1 visitor category. Isn't that funny? B1 visitor. What does a visitor do? Anything but work. You're not allowed to work in the United States. Can you be on assignment from some overseas company to come to America to explore ways to set up a business? Yes, that you can do. That you can do. But to say this is a pathway, it's baloney. It's the first step in a huge path that goes a long way into the future. It's not the solution. It's just the start of your journey. USCIS entrepreneurial idea number two, the F1 OPT pathway. That's another wonderful idea, except again, is 1 year or a STEM extension of OPT beyond 1 year really enough to then have a company that is financially solid and that has a fiscal track record to sponsor a work visa? Again, To make the OPT self-employed option pathway work for you, you got to figure out a way to get that business up and running during the OPT period so it is substantial enough to pass the other immigration tests for the real work visas, O, the H, and so on. As a pathway, it's the first step on a long journey to the path of work visa. It is probably an alternative to item number 1, the B visitor. Item number 3. Why can't we use the H-1B as a vehicle, a pathway to get work status for the entrepreneur? Why can't we? I'll tell you why. What else is new? Immigration has not kept up with the times, and instead of adapting to the age of the internet, they have instead doubled down on the 1965 interpretations of the immigration rules, given the presumption of an employer-employee relationship. Of immigration basically says, you know what? We need to establish the employer-employee relationship. You got to have it. If you don't have it, there's no H-1B. It ignored the fact that in an entrepreneurial company, the owner, the boss, and the worker is usually the same person. Item number 4, the O1. That's good if you're extraordinary. And it's also good if you're willing to sweat blood like immigration wants you to prove you're O1 extraordinary. There's going to be a whole video on this one. Okay, immigration ideas for the entrepreneurial pathway. Ideas from immigration number 5 and number 6. And I got to tell you, these are real. These are real. Number 5, the E2 non-immigrant treaty investor visa. I have a whole video on this one, and I'm putting it in this playlist. Take a look. Number 6, the L1. You got your L1A, you got your L1B. These are really good choices too, and I have a whole video on this in this playlist, so take a look. These 6 choices that they list in the non-immigrant work category are a bunch of baloney. The only two real ones are 5 and 6. You know what's going on here? It's to quote former presidential candidate Barack Obama back in 2008. He infamously said, you know, you could take lipstick and put it on a pig, but you know what you still have? A pig. I don't know what to do. You gotta laugh or you gotta cry. That's the only two choices you have. Taking a quick look at the last 3 options immigration offers, they say, you know what? Why don't you just get a green card, which means immigrant status, which means lawful permanent residence. There are 3 good choices, but the trick is these were always choices. They're just taking all their pre-existing categories and dumping them into this fancy new website they call the Entrepreneurial Pathway. So let's see what they're talking about. Immigrant visa, choice number 1, the EB1 Extraordinary Ability Green Card. Well, sure, why not? We, in this category, say to you, if you are extraordinary in the field of business or science or engineering or mathematics or computer programming, step right up and apply for your own green card. We don't even care like we do for the non-immigrant categories. We don't even care if you have a business or if you do have a business if it's too small. We don't care. You're so smart. You're so talented. We want you here. This is a good choice. Not bad. I've got a whole separate video on this. It's the self-sponsored green card video. Take a look. The second category that they talk about is the EB2 advanced degree category, and it's usually in conjunction with the national interest waiver. And here's what I mean by that. You're smart and you're accomplished and you're working hard to promote the national interest of the United States in areas like nanotechnology, biomedical technology, mathematics, big data analysis, analytics, personalized medicine, and developing renewable sources of energy. These types of things will give you a green card. We'll give you a green card because you're working in the national interest. We want you here. And again, we don't want to hinder you with this requirement like we did for the 6 non-immigrant categories. We don't want to hinder you with the requirement that you need a job offer or that you have to have a company sponsor you. So you can have no company, a very small company. We don't care because we want you. So again, this is a real thing. The last category that immigration offers in the immigrant section of their entrepreneurial pathway website is the exceptional ability, the EB2 exceptional ability, and that normally is lumped in with asking for a national interest waiver, meaning it's in the national interest for us as a nation to retain people with exceptional ability. Now, what's that? You're good. You're head and shoulders above your peers. Your peers with similar years of experience are here. You are way up here. And we want you. We don't care if there's a business behind you. We don't care if you have an entrepreneurial business that's successful or not successful right now, because we know that in the future it will be. So come on, apply for a green card. Here's what they're not telling you. There's also an EB2 perm labor certification. The great majority of green cards based on work come from the perm labor certification category, and I've got a whole nother playlist about this. But the joke or the insult, one or the other, the joke or the insult with the perm labor certification, which is the vast majority of all the green cards issued through employment, the bedrock concept of perm labor certification is the employer-employee relationship. No green card for you. You can't get a green card if you start your own business and be sponsored by your business. Because, why? In 1965, everyone, when these laws were written in 1965, everyone was an employee. You went to college, and then you went to work for General Motors or IBM. And this dichotomy, employer-employee, was natural. The rules need to be ripped up, and we need to start over. But given that we're stuck with what we're stuck with, this playlist will, I hope, give you ideas with a really good dose of cynicism to make you think about ways to realistically beat these very, very old-fashioned, out-of-date rules. If you have questions, send us an email or give us a call. We're standing by.